Good afternoon, everyone, and a warm welcome to the current session. That is the new facets of consumer protection. We can say this is a special session since our researchers are going to bring to the light the new emerging and also the existing but the least known concerns of consumers. As the name itself suggests, this is an exceptional and unique session meant for exposing the new challenges and exploring the new possible remedies for consumer protection. The recent growth in the technology has made the lives of the human beings and consumers very easy. At the same time, they have posed various threats to the human beings and consumers. We can see that the recent growth in the IT sector has given a huge boom to the e-commerce sector, which has again posed various threats to the consumers, such as threat to the privacy of the consumers, then unaccountability of the seller or the platform manager, and unavailability of the identification of the seller or the company, which are causing delay in redressal of the disputes and which are creating many hurdles for the disposal of the consumer cases. Innovations and development of various products in the recent decades, such as plastics, pesticides, radiation emitting mobile phones, paints, makeup kits, are carrying various health risks. Products such as plastics are entering the human body through the water and food, and pesticides are entering the nervous system of the human beings through the residues through food and water, and radiation emitting mobile phones are damaging the nervous system of the human beings, and these makeup kits, paints, these are posing various health risks to the consumers, and the health risks posed by these things are not very popular, so that are being ignored by the consumers, and in the long run they are causing various diseases such as cancer. Many times these products are linked to the diseases such as cancer, and privacy of the consumer at various apps and e-commerce platforms is really concerning, but these things are being ignored. Also, major challenges have been seen in the medical, pharmaceutical, and IPR sectors. Majority of these things are going to be addressed by you people in the today's conference, and I would like to thank presenters on today's panel for their amazing topic selection and contributing to the ocean of the research in the consumer law by showcasing their original and creative ideas. Thank you. First of all, now I would like to request Mr. Faisal and Ms. Arijita Mukherjee to present on critical analysis of Bolam test as a basis of determining professional negligence with special reference to medical negligence. You people have got 15 minutes, and best of luck for your presentation. You can start presenting, Faisal and Arijita. Over to Faisal.
Sir, just 1 second. I'm trying to start the video. Yeah, I've submitted my slides. Can I see my slides, please?
Just a minute, Faisal.
Yeah, okay. Yeah.
Sir, those slides were for the backups. If you can share it right now, that will be really helpful. If not, then we can share it on your behalf.
If you can share, okay, I'll try. Give me a few seconds. Give me a minute. I think it is in my lab.
Please note all the other participants. If you have your slides with you, please share it. If not, please let us know in the chat box so that we can keep it backup.
Tasneem, you are going to show the slides on behalf of the presenter?
Yes, sir. Just give me 1 minute.
Yeah.
So the next present is the next presenter ready? So we might move ahead with them and
Yeah, I'm trying actually. It's in this
Okay, I got
email, so I think there's some update, something going on.
okay.
It's getting downloaded.
Okay, no problem, sir. We'll be sharing it now. We have it. Okay.
Okay.
Yeah, Faisalji, you can start now.
Yeah. I'm just trying to open the video. Actually, all of a sudden,
Thank
all
you.
these updates have started. Just give me a second. Yeah. Can I start now?
Yes,
I hope I'm audible clearly.
yes, you are audible.
Yes, sir. Please.
All right. So the topic of our presentation is Bolam test. See, the success and failure of any profession depend on certain factors which are beyond the control of professionals. But still, we expect that some kind of competence professionals should have because they owe legal and the moral duties towards the beneficiary of their services. So it is a settled position that the professional will be held responsible only on one of the two findings. So either it is absence of or lack of skills or improper application of such skills. So the set of skills which is required for practicing any profession is rightly decided by the professional body and association related to that particular profession. But the question remains whether the standard of care should be exclusively within the domain of that particular professional discretion, or it should be a matter of legal accountability. So this presentation is about exploring this particular test, which is one of the most celebrated and popular tests for determining professional liability. There are a lot of tests propounded over the period of time, but this is one of the most celebrated, which was propounded by House of Lords in way back in 1957. So it reached its popularity in 1980s and in the early 1990s. But from the mid 1995, there's a clear trend in places like Australia and in fact in the United Kingdom itself, where they went for the shift from this particular test in cases like Bolam, Rogers, among others. But ironically, what is very interesting to note is that precisely in 1995, the Indian courts, they started applying this particular test, and it has become a popular precedent, and it is the most important factor in the Indian court. So the leading case on this particular point is Indian Medical Association versus VP Shanta, where the Supreme Court of India said included medical service within the ambit of the Consumer Protection Act, even though it was not expressly mentioned in the 86 Act. So what we'll do in this particular presentation is we'll probe the efficacy of this particular Bolam test in general and in the context of medical professional in the Indian situation. So we have divided, I can't change this slide. Can you please change the slide? Yeah, thank you. So we have divided the presentation into 4 parts. First, starting from the analysis of the Bolam test, followed by limitations and the application in Indian context, and we'll end the presentation with our recommendation. So regarding the first, can you please change it? So I'll just give a very quick brief fact of the Bolam case. Please change the slide. So what happened in this particular case, 1 second, please change the slide. Can you change it from your end? Oh yeah, perfect. So leave it. So the brief fact of the case was the patient John Bolam, he was suffering from certain mental illness, and he underwent for electroconvulsive therapy, which in the layman's term is nothing but electric shock. But unfortunately, what happened during the course of the treatment, he suffered from a serious fracture in his pelvis. So he filed a case of medical negligence against the doctor on two grounds. The first was that a certain type of relaxant drugs was not provided. And second ground was that it was not a case of informed consent because he was not informed of that potential risk relating to serious fracture. The court took the opinion of various professionals, but the opinion of the experts were divided. So the court formulated the proposition, which can be broadly categorized into two categories. Number one, that if relaxant drugs was provided, there was a minimal chance of death. But if relaxant drugs was not provided, there was a minimal chance of serious fracture. So unfortunately, in this particular case, the patient, this minimal chance applied in case of Bolam, and he suffered from the serious fracture. So the issue before the court was whether the act of the doctor was negligent or not negligent. So the court said that it was not an act of negligence because providing relaxant drugs or not providing relaxant drugs, both are accepted practice depending on the nature of the case. So they have propounded two principles, which is popularly known as Bolam test. The first principle is that for any act or omission in question, the standard should be compared with an ordinary competent professional exercising similar or same kind of skills in the profession, rather than comparing with someone who is having the highest form of expertise in the profession. And the second principle, they have said that they have recognized more than one method as an accepted method to deal with one particular problem. So apparently this test, it seems fair and reasonable, because we cannot expect the highest expertise from every professional, and recognition of more than one accepted method is perfectly fine, which is the part and parcel of most of the profession. However, when we go for a closer observation of this particular test, we have found that there are quite a limitation. There are quite a few limitations actually of this particular test, and that is one of the reasons that it has lost the popularity. So please change the slides. So now we come to the second part of the presentation. So this is the main part of our presentation, which is about questioning the test per se, and then we'll try to apply in the Indian context. We have divided all the limitation into two broad categories. One is about the objection to the test per se, and second is about the extended application of the test. So we have prepared 6-7 ground regarding the objection of the test. There's a slight overlapping. Just to emphasize this point, we have made it 6-7 ground. So starting with one, I'll just quickly explain this. The first is about there's a possibility of multiple interpretation. So at least there are two possible interpretations which will come, which has been highlighted by various scholars who have conducted research on this, that there can be a descriptive interpretation of Bolam test, but Bolam case has not clarified which is the correct interpretation. Descriptive interpretation means the court will simply act as a rubber stamp where the expert opinion comes in the court of law, and the court will endorse that particular opinion for deciding whether the act is negligent or not negligent. So all that is required is the defendant has to produce opinion of one peer that he would have acted in the manner he has done this particular act. On the other hand, in case of normative approach, the court will not simply act as a rubber stamp. Rather, the court will go for the assessment of that particular evidence, and the court will use its own logic and reasoning, and then they will take a call. Moving on, there's a big dilemma about what is accepted and what is not accepted. So in the Bolam case, the House of Lords has said that it is the responsible body of men, they will decide that what is accepted and what is not accepted. But the question remains that how to decide that who is responsible body of men, whether it is on the basis of expertise, whether it is on the basis of experience, whether it is on the basis of both, whether it is on the basis of affiliation with institution. So we are not sure of that particular thing. Moving on to the third point, that is something very, very interesting, the most interesting of all. There is a possibility that being a professional, I can conform to the standard, which is accepted standard, but I don't have any expertise whatsoever. So a simple example could be, which I have mentioned elsewhere, take a case of a simple fracture. So say there's a particular kind of fracture. Now there may be two schools of thought. One will say that this particular fracture requires, surgery, minor surgery. And the other schools of thought say that maybe this fracture doesn't require surgery, only through plastering and medication, through calcium tablets and all, it will be healed. Now imagine a case, I'm a professional, I have been practicing, I'm following a school of thought which practices surgery, and I have been doing that for years. Now suddenly on one particular day, I thought of experimenting with a patient with the plastering, which is also a practice done by other professionals. So imagine that I have tied the bandage, I have provided medicine, but something has gone wrong, because I don't have the actual expertise in that particular thing. So if I am charged for negligence, I will argue that, see, I have followed one of the accepted practices, hence my act is justified and Bolam will justify my act. But in reality, the interesting part is that I don't have any expertise regarding tying the bandage. So that is something, there's a chance of, confirming to the practice where I don't have actual expertise because someone else is practicing in the world. Moving on, there can be a lot of competing opinions. So we don't have any solution. Bolam has not provided how to deal with the competing opinion. And, there's often a debate like whether third opinion should be taken, whether fourth opinion, fifth opinion. So we don't have any clarity about what will happen if there's a competing opinion, which one will be taken over the others. Now, there are other two problems. Sometimes there may be an inherent defect in the profession itself, because we are aware of that medical science is inexact, is a developing science. So it is developing every day. Now, one case, which is an apt example to explain this particular point, is again the case of House of Lords, that is Roe versus Ministry of Health, decided in 1954. So in Roe versus Ministry of Health, what happened was, I'll just quickly touch upon the fact. So a person was given full anesthesia, the operation was going on, but in the middle of the surgery, suddenly the patient got up and he suffered from various medical complications. So he filed a case for negligence against the professional who administered the anesthesia. The professional argued in the court of law that he followed all the medical protocol for preservation as well as administration of anesthesia. So there was no fault on his part. The lab report suggests that there was contamination with the anesthesia. On the further probing, they realized that there was a problem with the entire, the practice of preservation of anesthesia itself in 1954, which was a very, very old practice. So I'll just quickly explain that. So what they used to do, they used to preserve anesthesia in the glass bottle. And just to ensure that microorganisms should not enter inside the bottle, they used to apply certain chemical in the outer surface of the bottle. What they were not aware of, that this particular chemical, which was supposed to be protector, they was actually the culprit. They used to sip through the glass, and at times they used to contaminate anesthesia. So we are not aware of how many people have suffered. So there is a problem of chances of inherent defect with a very, very old practice. But Bolam is something which is, kind of static. So this is connected with point number 7. There's a very big question again, the Bolam test, that whether it is an obstacle towards, innovation in the medical profession, whether it promotes defensive medicine, whether it's a hindrance towards improvisation in a particular case. Because being a professional, I may develop an expertise through my independent research where the conventional treatment may not work, but I can always improvise for a particular patient. But if I'm aware of the Bolam test, I'll never do that, because improvisation is about countering the Bolam test. And last, the case of widespread public opinion. There are cases where certain practices by the medical professional, those are not within the public opinion. So the case of organ retention case, that is a very, very notorious case where all the medical professionals, what they used to do is whenever the baby would die, a tender age person, so without taking the consent of their parents or guardian, they used to retain the organ. Now this was hugely criticized. All the doctors, they argued that it was an accepted practice of the profession, therefore Bolam should apply. So the court did not apply Bolam test, because by that time, this is 2004 case, the Bolam lost its significance and Bolam was not the dominating force in other common law jurisdiction. Now, coming to the other part, the extended application of the test, what is really surprising to note, the Bolam was propounded where there's some sort of special skills required. Now, what is happening in India at this moment, they are applying Bolam test for each and everything as a matter of routine, even whether there should be informed consent or not, which is a matter of constitutional right. They are saying that this is the practice of all the doctors. So, full disclosure is not required in each and every case. So they're applying the Bolam standard, that all the professionals, they follow this particular standard. They're applying Bolam test for imposing liability of establishment like hospital, diagnostic center. But then the question is that whether these are all about special skills. It's a matter of rights that, whether I consent to a particular treatment or I don't consent to a particular treatment, there should be complete disclosure. So the choice should be given to the patient rather than just applying certain standard, which is a practice within the profession. So this is a very quick overview of the limitation. Now I'm coming to the third part of the presentation. Please change the slide. So yeah, can't follow the slide. I think this can.
Yeah, Faisalji, you only going to the present or your co-present?
No, I'll present the whole. So I can't follow the slide for some reason. I can't see the slide. 1 second, there's some problem. Can you please show the slide? It's not visible.
Ashni?
Well, now this is the main slide, our findings. Yeah. please change it. The next slide, please. Yes. There's a previous slide. Okay. Please leave it here. So what we have done in this particular case, we have taken all the cases of National Commission and the Supreme Court cases where the court has expressly referred Bolam. So all the cases can be classified into two categories, where one set of cases where they have applied Bolam without referring to the Bolam test, and other cases where they have expressly mentioned the term Bolam and they have mentioned Bolam test. So in total, there are 135 cases of National Commission and 37 cases of Supreme Court. We have done the quantitative and qualitative analysis of both the cases, and we have found some really interesting finding. Please change the slide. So the first thing to note from all these cases, majority of the cases are related to surgery. So this is something very interesting for us, because the cases which have gone for the appeal, starting from district and state commission, most of the cases are surgery, and we are aware of the the limited or what should I say, the Bolam test which operates in favor of the professional. So it's almost difficult, impossible, if very difficult, if not impossible, where the burden of proof is on the plaintiff, and plaintiff has to prove that the surgery was not performed in a proper manner, unless there's a clear case of leaving foreign material or body inside the patient. So it's very tough to prove for the plaintiff that the surgery has not been performed properly. So Bolam would apply perfectly whether that surgery was required or not required. But over here, the concern is whether surgery was not performed properly. So the burden is on the plaintiff. So this is a very interesting data for us, that most of the cases are related to surgery. Now, please change the second slide. Now, what is really surprising for us, so we have gone through all the cases and we have realized that most of the cases, it's almost 50-50, around 55% cases are where the court found it was negligent. They have decided against the professional. So with the limited Bolam test, most of the cases are cases where they have found it is the act of negligence. So one thing is very clear from here, that the black sheep has entered the profession. With the narrow Bolam test, they found that half of the cases are negligent cases and most of the cases are related to surgery. Please change. Again, interesting data is that the patient, generally they are interested in cases of death. So the death cases have gone for the appeal, and the number of death cases in the entire cases of medical negligence, that's a negligible case. But the number of death cases almost at par with no death case, which have gone for the appeal. And we have to note over here that all the appeals are filed by the professional. So they have lodged the case either in the consumer, most of the appeal, I should say, in consumer district commission or maybe state commission, and they have gone to the national commission and maybe even to the Supreme Court. So most of the cases are related to death. So in India, the trend is that, if there's a death of the patient, then suddenly the people, take action against, professional. Please change the slide.
Just
Please. Yeah.
Sorry to interrupt. Just wanted to remind you about the time limit. We are beyond it. So yeah, please try to.
So I'll finish it in 2-3 minutes. Please provide me 2-3 minutes. Okay, this is another. I'll try. So this is another interesting finding. That almost all the cases are from private hospital. Now, this data is deceptive for a layman, because the reason is that public hospital are not covered under the Consumer Protection Act. So that's the reason. That doesn't mean that private hospital are involved in all the negligent act. If today, public hospital comes over here, chances are it will be, this graph will get reversed, and maybe negligible case of private, and most of the cases will be public. So these are the 4. There are a lot of other findings we have not kept over here. So these are the 4 findings which is very crucial for our discussion. So now please change the slide. Yeah. Okay. I think this is the one. So before coming to recommendation, what we argue in this paper actually, that the result of the research is, it was not anticipated actually. What we thought, that the Bolam was applied in the cases, and the number of conviction or the cases decided against the defendant would be very less, and especially given the fact that those are surgery cases. So it's a kind of eye opener for us, that even though most of the cases surgery, narrow approach of Bolam, and still there are so many conviction and the cases decided against the defendant. So we have proposed 2 hypotheses. In fact, we have formulated 2 hypotheses. One is that the normative approach of Bolam has been applied, where the court have gone for the assessment of the evidence rather than just endorsing the view of the the professional. And the second hypothesis is that the court has gone with the descriptive approach, where they acted just as a rubber stamp, and simply they applied the view of their peers and held that those are cases of negligence. What is really surprising is our understanding of all these cases, when we have gone through, we endorse the second hypothesis that these are all clear cases of negligence under civil law. Court has gone with the descriptive approach, not normative of assessment of the evidence. So we can see that there are actually quite a few cases. So we propose that in high time, Bolam should not apply religiously in every other cases of negligence which comes in the country. It is very important to note that it has lost its significance exactly during the time when India adopted this particular test. So it is very much evident from the place of where they have propounded this test. The same House of Lords in 1997, in the case of Bolito versus City Hackney Health Authority, they deviated from the Bolam and they said that Bolam is not a universal test. If we take the example of other common law jurisdiction, for example, Australian Supreme Court in Rogers versus Whittaker, they have said that Bolam should not be the standard. But on the other hand, we have just followed this standard blindly. So it's really high time that we should go away. We should be done away with the Bolam test. So what we recommend is, basically there are 5 recommendations. So the first is about if there's a case relating to consent, where it is not related to special skills or anything. The finding of Rogers versus Whittaker is the perfect example formulated by the Supreme Court of Australia. What they have said is, in this particular case, the person went for eye operation and the risk was 1:14,000. So the patient was not informed.
Faisal ji, please conclude.
Oh, okay, I'm just concluding. So what we are proposing
1 minute only.
Yeah, I'll conclude in 1 minute. So in Roger case, the Supreme Court said that there should be full disclosure irrespective of the minimal risk and all. So Bolam should not apply, even though it is a practice of all the professionals. Second, they have said a Bolito case should be applied whenever it is feasible for the court to go for the risk-benefit analysis. And if at all Bolam should apply, the normative interpretation of Bolam should be taken, where court should not merely act as a rubber stamp, rather the court should go for the assessment of actual evidence. And this, we have found that one situation where the descriptive Bolam approach, which is a dominant factor in the entire decision of the Indian court since 1995, that may be in the case of criminal liability, because now we are separating criminal negligence with civil negligence. So this are our suggestion that Bolam should not be used as a matter of routine. Thank you for giving the opportunity. Thank you very much.
With the permission of my co-chair, sir, we'll take questions right now or at the end of the session?
Take it at the end of the session, sir.
Sir, I can't hear you.
We can take this at the end of the session. We can have a question and answer session separately at the end of the session,
okay,
sir.
Okay, then I would like to call upon the second presenter, Vikranta Pandey Barse, going to present on is Grindr responsible and liable for the criminal offences committed over its application against its users. Over to you, Vikranta.
Yes, sir. Do let me know, am I audible?
You are audible and you have 15 minutes of time,
yes, sir,
for the finishing your presentation.
Is my screen visible?
Yes.
Yes. Good afternoon to the esteemed chairpersons, the moderators, my fellow presenters and the audience. I, Vikranta Barse from the National Law University and Judicial Academy, Assam, will be presenting today on the topic of is Grindr responsible and liable for the criminal offenses over its applications against its users. Now, the thing is, in 2009, when Steve Jobs announced that the second generation of the iPhone would allow for the installation of third-party applications, we had Israeli entrepreneur Joel Simkai, who basically capitalized on this opportunity and launched Grindr on February 3rd, 2009, which happened to be the first dating application on the iOS platform that makes use of Apple's geolocation technology. Grindr was more or less meant to find other gay and bisexual people within a particular radius. Now, the thing is, the uniqueness of Grindr was that it borrowed the concept of making profiles of mainstream socializing from its predecessor application called as Gaydar. At the same time, it is a location-based application. As I've already told you, it gives you the prospective people within a particular radius. And at the same time, it champions the principle of variable ratio reinforcement, whereby a user is, addicted to constantly checking their phones multiple times a day in order to get rewarded with an unpredictable reinforcer in the form of finding an interesting match. Now, the thing is, historically, heterosexual people have the benefits and the privileges of being widely accepted and recognized in mainstream media. So Grindr took the advantage of that, and it provided a homosexual person to find another homosexual person via a online catalog of other people, where the endless possibilities are at bay, where you could find a person for direct sexual intercourse to finding a person for a sweet date. This unique characteristics of Grindr allowed it to have an expansive user base of almost 13 million persons per month, with 4.5 million active users per day globally by the end of December 2020. And by December 2021, India became the second highest user of Grindr, with the second highest number of users on the application. Now, if you look at the current scenario, it's a great thing that you have an application that allows for minority dating, but the ease of making an account, the lack of verification of the genuineness of the user on their profile, and the discreetness and anonymity offered by the application to its users and their various applications done actually opens the doors to multifarious criminal organizations or criminal activities that happen on the application. The turning point for Grindr was the trial of Daniel Jenkins, where his co-conspirators and they used fake profiles on Grindr, where they lured innocent and unsuspecting men into an apartment where they were held at gunpoint and assaulted and robbed. Although the court sentenced Daniel Jenkins to 280 months in federal prison, the interesting point to note here was that Grindr was never asked to be liable in any case. The situation in India is no less, it's much grimmer when we look at the case in Ahmedabad, where a gang of 4 men lured an innocent man into a hotel using, again, fake profiles on Grindr. The gang members secretly filmed an explicit video of consensual sexual exchanges between the victim and one of the gang members. And then that video was basically used to threaten the victim to exchange or to give up a sum of money. Another case is the case in Gurugram, where we have a gang of 5 members who again befriended, lured, and extorted money from almost 25 innocent men using fake profiles on Grindr. The extortion, the base was very simple, that they used videos in order, and they threatened that we would expose this video on the internet. We would show it to your friends, your family, the relatives, and your employer. And that is how they were used to extort money from these innocent victims. So we see that crimes on Grindr more or less follow a very, very straightforward modus operandi, where we have these gangs which assume fake identities using doctored photographs from the internet, and then these victims are lured into common public places under the pretext of, let's have an innocent date or a casual sexual meeting in a hotel or an apartment. And the victim is taken to a hotel room, apartment, or a car by one of the gang members, and then the gang member would signal the other gang members to come in. Then they ambush the victim, and then the victim is assaulted, robbed, and sometimes sexually assaulted and raped using an active threat. Now, this active threat can take place in 2 cases. One is active threat to life, where the victims are held at gunpoint, or they're either tied and gagged, where they feel that their life and well-being are in active danger. Or you have the threat of stigmatization, where the victims are threatened using videos of them in compromising sexual positions, where they feel scared that their friends, family, employer, and relatives will now know about their well-kept sexual secrets. Now, you might wonder why the threat of stigmatization has been included here. In countries like India, the threat of stigmatization goes much beyond than the threat of life, because although the same-sex relationships were decriminalized in 2018, stigma towards homosexuals persists within many religious and conservative communities, especially in rural and semi-urban areas. At the same time, crimes against homosexuals get rarely reported to the police because of something called as anti-gay bias and further prosecution by law enforcement agencies. At the same time, homosexuals fear that they might end up exposing their sexual identities and sexual secrets if they go to report the crimes to the public at large. Crimes and syndicates take advantage of this threat of stigmatization, as it was seen in the case of Delhi NCR, where almost 50 senior executives from top companies and MNCs were threatened with with sexually explicit videos in order to extort large sums of money. So we see this is not a one-off situation that I'm discussing here. There are multiple instances where crimes have happened over Grindr. Now, a user's experience on Grindr stems on 3 platforms or 3 pillars. We have something called as community guidelines, we have privacy policy, and we have terms of service. You might have noticed it whenever you take any application, you're always made to say, yes, I agree to these terms and conditions or terms of service. Now, if we look at this terms and service that Grindr so presents, section 11, subsection 4 particularly, it says that Grindr has the right, but it has no obligation to monitor the content of user accounts and profiles for any purpose whatsoever, wherein the application pushes the sole responsibility onto the user for all the content provided by them on the application. Another look is section 13, subsection 5 of the terms of service, where Grindr says that it has no responsibility or obligation to actively monitor or modify or remove any inappropriate content. Again, if you look at section 2, subsection 3, Grindr says that it takes no warranties regarding the accuracy or reliability of the information or the content that is produced over Grindr by other users. So we see here that Grindr, at the end of the day, takes no responsibility for anything said or done by any user, wherein it becomes the sole responsibility of the aggrieved user to become responsible for their interactions with other users, including the impersonators, which is exactly what these impersonators take advantage of. So here is where it comes as to why I am here, why I am talking about all this. The large number of users that exist on Grindr in India and the widespread instance of criminal offenses on Grindr prompts us to look at what is the responsibility and liability of the platform itself for these criminal offenses. Because the way Grindr is designed, for the way Grindr gets operated, for the way Grindr is put out, it becomes possible for nefarious individuals to, commit these criminal offenses against innocent men. Now, there are.
So can you correlate? Sorry for the interruption. Can you correlate with how to protect the users?
Yes, I will be getting into that, sir. Yes, I'll shortly get into that. Almost there, actually.
Yeah, go ahead.
Yes. So Grindr comes in two forms. One is the free Grindr, which is more or less downloaded from Play Store or Apple Store. And then you have something called payable Grindr, which is basically Grindr that you have to pay a subscription charge, and then you go towards something called as Grindr Extra, Grindr Unlimited, wherein upon it has its respective subscription charges. Grindr Extra allows you to see more than 500 to 600 profiles at once, and it allows you to chat with people across geographical boundaries. Grindr Unlimited, on the other hand, takes off all limitations. You can chat with, like, a person in Bombay can be chatting with a person in Tokyo. There's no limitations and geographical boundaries. You have greater photo sharing capabilities. You can share one-time pictures, etc., etc. So we'll be looking into the liability of Grindr as its free version as well as its paid version. So first we'll look at the free version of Grindr. When it comes to the free version of Grindr, as my previous presenter has also pointed out, although albeit in another context, free version of Grindr will not be considered within the Consumer Protection Act, because we have a famous judgment here, which is the Indian Medical Association v. VP Shanta, which says that services rendered free of charge will not come under the ambit of the Consumer Protection Act. However, an argument which was put forth by a lot of people is that, imagine I'm the user of the application. Obviously, I'm using it using the internet. I either use cellular network like Vodafone, Jio, or Airtel, or I use an internet service provider. And at the end of the day, I am providing some fee to, I'm recharging my phone either postpaid or prepaid. So I am paying some money to access the internet, to use the application. However, it is interesting to know that in the case of Municipal Corporation of the City of Baroda, v. Babubhai Himmatlal, it was held that a fee is a payment by the, it's for a special benefit or a privilege, wherein a particular fee gets paid because of the specific services which is rendered to a specific class of people. So the fee that is paid by the user here for internet or by their respective internet providers, although it has direct relation to the services that are so used on Grindr, because you cannot access Grindr without the internet, the fee is paid by the user cannot be considered as a consideration within the Consumer Protection Act, because this fee is paid to the internet service provider. You either pay it to your SIM card provider, or you pay it to your ISP or the internet service provider for giving you your Wi-Fi services, etc. You're not paying this fee for the services provided by Grindr. You're not providing the money directly to Grindr. So which is why it becomes difficult to see how Grindr could be liable within the Consumer Protection Act. But does this mean that these consumers are left defenseless? The answer is no. We have something called as tort, the tort of negligence. Grindr has the duty of care towards its users, because every person has a reasonable duty of care to take place of the other. Obviously, if you have reasonable foreseeability. Now, obviously, Grindr knows this, that there is a possibility that the users can be possibly injured by the use of services on its applications, and at the same time, The negligence that Grindr has been doing towards not changing its application amounts to the breach of its duty of care. Now, Grindr-related crimes have been observed as early as 2017 in the United States of America, when we saw multiple counts of assault, robbery, and crimes using a firearm by Nigel Garrett in 2017. At the same time, between 2013 and 2015, we saw a rise in the criminal offences over Grindr in England and Wales from 55 in 2013 to 412 in 2015. So we see a jump from 2013 to 2015. So it's not like the instances of criminals using the application is not well founded. It is very well vetted. It is very well founded. And the company ought to foresee the likely damage that the application is going to do to its prospective victims or prospective users if they fail to exercise reasonable duty of care. Now, at the same time, being the largest location-based social networking application for the LGBTQIA+ community, that the duty of care imposed on Grindr is actually just and reasonable. At the same time, the high amount of users in India and who have suffered considerable damage and injuries because of Grindr also does not allows for us to have reasonable duty of care that gets imposed upon Grindr. Now we come to because I think because of paucity of time, I've already explained all of these, but I would touch upon that Grindr has failed to perform its duty of care by failing to exercise proper control or supervision over the profiles and accounts of nefarious criminals and impersonators. At the same time, these users who are using the free version of Grindr, they lie proximal. They have direct effects to the actions or omissions that is committed by Grindr upon their personal health, injuries, etc. So it satisfies the test for negligence that yes, your users, they are your neighbors, they are proximal to you, so you have a duty of care towards them. Now, when it comes to payable Grindr, obviously now because you're paying a subscription charge, users of payable Grindr become a consumer within Section 2, Subsection 7 of the Consumer Protection Act of 2019. And because you pay a payable charge, you now come within the ambit of the Consumer Protection Act. Here, I would like to tell you there is something called the Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules of 2022, which was basically it's an adjunct to the IT Act in itself, IT Act of 2000. Now, if you look at the terms of service, we have extensively discussed the terms of service of Grindr. Grindr, if you look at Section 11(4), Grindr does not control or monitor the content of its profile. Grindr does not modify any inappropriate content, and inappropriate content also includes that of impersonators. Under Section 13(5), Grindr claims no responsibility for the conduct of other users on the application. Section 13(5) again says that it makes no warranties regarding the accuracy and reliability of any content. So we see that Section 3(1)(b) of these IT rules, as we have so seen, the full form is right here, of the IT Amendment Rules of 2022, it requires applications like Grindr as an intermediary and a social media application to prevent any form of impersonation or intentional misinformation or patently false and untrue information over its application. But a thorough review of the terms of service tells us that Grindr is willfully violating the IT Amendment Rules of 2022, where it is not taking any measures to avoid impersonation over its application, because of which Grindr is now liable for deficiency in services. The services on payable Grindr, they obviously suffer from an inadequacy as required to be maintained under law. The law that we are referring here is the IT Amendment Rules of 2022. At the same time, Grindr has committed negligence with respect to payable Grindr by breaching its duty of care for its users against impersonators, because of which you have this deficiency of services which is committed by Grindr. Now, because you have deficiency of services, as a service provider, Grindr is now responsible and liable for the harm that is caused to a user who is a consumer, as we have seen, of payable Grindr.
Last 1 minute, Vikranta.
Yes, sir. Wherein the service provider is required to compensate for the aggrieved. Now, you might think that the actual office of Grindr, which is located outside the territorial boundaries of the country, how will we have the district commission, the state commission, or the national commission even look into this matter? And here we come into the issue of extraterritoriality. Although we have a lot of cases to look into, the gist of them is very simple. In all of these cases, a very central point was held that Grindr, though being an international entity, though being an entity outside the territorial limits of India, their actions result in a direct consequence to the users who are located within the territorial jurisdiction of India. They have a direct effect to the welfare and benefit of the people of India. They have a direct harm that causes to the people of India, which is why extraterritoriality can be extended to the international entity under Article 245 of the Constitution of India for the welfare of the people, which is why Consumer Protection Act 2019 can have extraterritorial applications, because its negligence and because its deficiency of services causes a direct consequence. You have a doctrine of territorial nexus that gets established here, because of which we can say that yes, you're liable. Users of payable Grindr who are so aggrieved can approach the commission at respective levels, by which the district commission can now issue an order to Grindr to remove any deficiencies in services provided by them on payable Grindr. Thank you, sir.
So, okay, we'll take questions at the end. I would like to call upon third presentation in this parallel session that is going to give by Sriyash and Kritika. And the topic is inclusion of the visually impaired as potent consumers and its implications, a compelling necessity. Sriyash and Kritika, over to you.
Good afternoon, everybody. Good afternoon, sir. Good afternoon, the chair. I hope I'm audible.
Yes, you are audible.
And I'm visible, sir?
Yes.
Okay, I'm a totally blind person. So if any veracity is kindly ignored. The topic that we have written an article is about inclusion of the visually impaired. That is what we call the blind people as potent customers or consumers, and how are its impact. Right now, the need for it, or basically the compelling necessity. So why have we chosen this particular topic is, so if you see in the past, you all like we came across visually impaired only doing this charity model and such as this, that is people used to depend on the others. Either they used to take money or food and such as that. So there was no what we call um, uh, a model wherein which people would go for employment and such as that. But today things have changed. Today people with disability, very precisely visually challenged, have been going for work, and there are particular laws for it and such as that. So having said this, even then we have products which are made totally inaccessible. I'd like to bring one of that example to your notice. That is, we have shampoo and we also have similar kind, that is conditioner. Both are similar. So if at all a blind person, if at all a visually challenged person has to identify, how would visually impaired person identify what is a conditioner or what is a shampoo? So that of course the European standards are there, and it is very accessible when it comes to products, when they make products, whether it is for not for blind or if it is for a visually challenged. So that model, that incorporation must be made even in a developing country like India is what we thought forth, and we put forth all of that in this particular article. And over to my co-writer, author, who is going to present from henceforth. Thank you.
Well, it's my pleasure. Thank you, Shiv. And per se, the act itself is not inadequate, but it is just that the implemental impetus to the act is what it lacks. So the Consumer Protection Act in total is an act that is being made for the entire stretch of consumers and not excluding the visually impaired. But what is the main challenge is that there is no reasonable accommodation made, and on the other hand, there are no accessible there are no accessible products or even services that are available for visually impaired. So this is what the research paper would want to address. So for the acquaintance, what is reasonable accommodation? Just making like small modifications and accommodations so that the visually impaired are being able to use the products completely, avail the services completely. So that is what is reasonable accommodation. And talking about accessibility, there are various methods such as imbibing new softwares that are already being present, and giving them technical awareness. So all of these can be measures that can be taken under the accessibility standards that must be taken. So what we want to propose is that the Consumer Protection Act has a lacuna and has a negligence in avoiding these aspects of reasonable accommodation and accessibility standards that are very much followed in some areas of India when it comes to the aspect of Delhi, for that matter, Delhi restaurants for that matter. They have braille labelings that are being present on all the commodities of restaurants and so on, so that the visually impaired can actually have a better social interaction and that they do not, excuse themselves from social interaction. So, it is also the fact that there may be a jurisprudential reference that the author just said, that there was this model called as charity model that was being based, where visually impaired were just sympathized for what they're doing, and they were not given complete recognition as potent consumers. But when it comes to the aspect of jurisprudential development that was brought forward through the functional model did recognize that the visually impaired are able to do something. So when we talk about this, I would want to throw some light upon what is the extent and scope of visually impaired as consumers. So according to the Consumer Protection Act, goods are being defined under 2 clause 21 of the act itself, and visually impaired are, of course, they are consumers of FMCGs. They are consumers of services such as telecom industries and amusement services. But have you ever thought about how these visually impaired would go on? Suppose you want to book a resort for an amusement purpose. We as sighted persons would want to go to the website and look at how the pictures have been portrayed, and we may make a rational decision in that way. But how would the visually impaired do this? So in the end, I will also be making certain recommendations and certain suggestions that we may have to imbibe in order to overcome all of these. So talking about how we have inaccessible checks, the checkbook that we write while availing banking services, visually impaired may not be able to fill the checks that we use as consumers, as availing the banking services. But what about the visually impaired? How would they fill a check? Because that is something that requires complete privacy, and it is to do with the financial transaction of the visually impaired person. So how would we have to overcome all of that is what we want to present here. Talking about reasonable accommodation, I would want to give certain instances of it. For example, in Delhi, I have already stated that there are braille labelings for acquaintance. What is braille labelings? It is just that there are stickers that are being placed where you have braille inscribed on it, and the visually impaired can actually use the just feel those dots and interpret what is the entire information. So talking about reasonable accommodation, even directional tactiles, that is visually impaired, use a cane in order to mobilize, in order to move, in order to mobilize from one place to another. So by using certain directional tactiles, we can guide the way in which they have to, for example, in metros, the use of directional tactiles, that is the tiles that have specific imprints, will lead the visually impaired to the train perfectly, to the metro train perfectly. So these are certain things that we would want to address from this. Now, talking about what are the accessible standards, WCAG, the Web Content Accessibility Guidelines, clearly states that all of the web content that is present, it is very crucial and paramount that it should be accessible even by the visually impaired. So how, in order to elaborate this a little more, for example, there is a necessity where you need to go ahead and make better navigation sites wherein the visually impaired are able to navigate from one button to another. because they use a software called as text to speech, which is NVDA, non-visual desktop access, and also JAWS. So these are certain softwares which helps them to read and interpret what is there on the screen, because these softwares read out whatever is there on the screen. They just interpret the text to speech. So these help the visually impaired in order to come forward. So apart from that, even the RPWD Act of 2016, the Right to Persons with Disability Act, made a major impetus, and it had a catalyzing process on giving better awareness on visually challenged persons and how they access their services and goods. So apart from that, it also throws light on how there is a need to emphasize on the right to access justice, because visually impaired as consumers are also denied their safety, their information, because much of the information that is present is not really in a accessible format where they can reach it by themselves. They always need an external aid in order to move forward with it. So for that matter, right to access justice, and also for that matter, availing medical services, it has a process where you
Yes,
have
sorry
to
for the interruption. Please conclude.
Okay, sure, sir. So I have a few suggestions which may have to be made. For example, there is a need for, where the clothing stores and all of that can have an imprint on how the braille labelings must be present, so as to the color specifications of the cloths that are being present. Apart from that, RBI in India has also made an attempt to bring forward the Money app, which helps in identifying the currency. So it identifies currency even if it is placed at different angles. And for that matter, AI Polyvision was another image interpreting application that was there, and it helps to read what is there in the image, unlike what a non-disabled person would have to look into it. So in total, what we hypothesize is that by not guaranteeing better rights for the visually impaired, importance of reasonable accommodation and accessibility must be paid heed in order to effectualize and accord the consumer rights equally, even to the visually impaired who are potent consumers. So we brought forward this critical doctrinal research that did make a reference to the WCAG guidelines, which need to be implemented, and also the consumer fora, which lacks much of accessibility in order to seek justice. So any product or a good or a service that a visually impaired would hire or avail, for that matter even buy, is a defective product and is a deficient service that he or she accords. Done, sir. Thank you.
Thank you, Mr. Shreyas and Krutika. So the next presenter in this parallel session is Navanita Warrior, going to present protecting consumer rights under the trademark law. Over to you, Navanita.
Thank you, sir. Good evening. I'm working as an assistant professor in SVKM's Jitendra Chauhan College of Law, and I'm pursuing my PhD from Amity on the topic protecting transborder reputation of trademarks. So basically, my interest on this topic, that is protecting consumer rights under trademark law, came to my notice when I was doing my research for my PhD. That is why whether trademark law is protecting the interest of the consumers, whether it is deviating from the primary objective of protecting the interest of the consumers. So throughout this presentation, I'll be introducing what is trademark and how what all are the traditional functions of a trademark law, then what all are the rationale behind the protection of a trademark, the rationale behind the protection of the consumer rights, and what is the interconnection between the trademark law and the consumer rights, and some of the problems which I have identified regarding the protection of the consumer rights from the point of view of a trademark. So trademark, as everyone knows, is a mark which depicts the source of a goods or services. It is a mark which is capable of distinguishing the goods and services of one person from that of the other. Now, traditionally, the trademark is there from the origin of a mankind. So earlier, what happened is like when a person was want to identify his cattle, a person wants to name a cattle, they used to put a mark on the cattle. Later on, as the time passed in England and all, what happened is like there became a regulation that you have to affix a kind of mark onto your goods so that you will be having a responsibility of offering a particular quality to the products. For example, on the swords and all, it was mandated that you have to affix a mark so as to distinguish or so as to understand who is the person who is making this particular sword, or who is manufacturing this particular sword. Similarly, on the bread, which is bread, also a particular mark was to be like made so that it is capable of distinguishing who is making the particular product. Now, what is the rationale behind the trademark protection? Whether the trademark protection is to be taken into consideration in the same sense as previously. So with the industrialization and the globalization, the trademark has got more importance, and people started understanding the importance of a trademark. So people, manufacturers, or any person who is providing a services started trademarking their products or their enterprise so that they become unique and the people will be able to understand who the particular seller is or anything. Now, what is the rationale? What is the reason behind the trademark protection? So basically, there are certain functions, or there are certain reasons why trademark is being given protected. And as everyone knows, we in India, we have the Trademarks Act of 1999, which is based on the Agreement on Trade-Related Aspects of Intellectual Property Rights, which provides protection to the trademark. Now, this act has been enacted with certain objectives, or with certain the act is stating there are certain reasons why a trademark has to be protected. One of the reasons why a trademark has to be protected is because of the origin function. That is, a trademark helps us in understanding from where the particular product is originating. So you will be able to understand the source of a particular product. So from the point of view of a consumer will be able to identify if I'm seeing a particular like milk packet. By looking into the trademark, I will get to know from where this particular product is. And I, being a person who believes in a particular brand, will be able to identify that product as coming and will be able help in making my in decision making. The second function is quality function. That is, a trademark, if you are affixing a mark on a particular product, it will help us in understanding that this particular the goods bearing that particular mark are having a particular quality, or is assuring a quality. And the third is advertisement function, which is more like a commercial in nature. It will help in promotion and advertisement. So these are the three basic functions of a trademark. So the trademark law, if you see, the basic objective of the trademark law is not just to help or to protect the manufacturers or the traders. The basic objective is to help the consumer, so that the consumers will not get confused when a series of products are being placed before them, and the consumers will be able to make a recent decision. They are not getting confused and they don't end up in buying diluted products or counterfeited products. Now, when you see the consumer rights, as per the Consumer Protection Act of 2019, the rights and the previous act, the consumer is having certain rights, that is right to safety. Now, what will happen when you are getting a deceptively similar product? That is a mark with a product with a deceptively similar trademark. Whether your right to safety gets affected, we all know the consumer is having a right to safety. Now, we are having a right to be protected against against things which are not safe. The second, right to information. We all have a right to information, right to know what the particular product is, where the source of the product is. So, but the question is whether your right to information will get affected by deceptively similar trademarks. If the trademark is not getting protected, whether your right to information gets affected. So basically, in that connection, I would like to quote something called cyber squatting. Cyber squatting is wherein a particular website wherein you are registering a domain name based upon an already registered trademark. So what happens is, like, if you are trying to get information about a particular product, who a particular service provider is, or who is the manufacturer, and you end up getting confused because of the problems like cyberquatting. So your right to information is also getting affected. Then right to choose, right to hurt, right to redressal, and right to education are the basic rights which a consumer is having. Now, I would like to look into the interconnection between a consumer rights and the trademark. So basically, there are certain functions based upon the functions which a trademark is having. You can get to know what is the relation between a trademark, trademark and the consumer rights. So the first one of the function which a trademark is having is the identifier function, which helps helps the consumers in identifying what all are the features of a particular product, will help us in understanding where the particular product is from, and help it, or simply helps us in understanding the source of a particular product. Now, regarding the identifier function, when connecting to the consumer rights, this will, if you are able to understand where this particular product is coming from, or what are the features, it will help us in our decision making. It will help us in choosing the best product based upon best product. Now, another thing is product distinction function. That is another thing, another function which a trademark possesses. So what happens is, like, when we compare a particular product with another product, when you are having a trademark on a particular product and the trademarks are there on other products, you will get a comparison. You will be able to distinguish what a particular product is and how it is different from the other product. And this will help us in decision making, and this will help us in making decisions based upon our prior experience. And if our experience is not good, you will refrain from using that particular product. Communicator function, trademark also helps us in advertising the particular product, and will help us in connecting to the consumers. Now, with the increase in technology, with the increase in advancement of technology, what happens is, like, a particular product is not localized in a particular geographical location. We can get the products by sitting in India. I can get a product anywhere, like from around the world, because of the e-commerce platforms, as well as various platforms which help us in availing the products. But what happens is, like, under the trademark law, there is nothing called a transporter reputation of trademarks. So a trademark, if I want to get the registered, it is localized. I can get the registration if I'm applying in India. Only in India I will get protected. There is nothing called transporter reputation. So for each country, I have to apply separately. And but transporter reputation, I cannot fully say there is no transporter reputation. Transporter reputation has been recognized only for well-known trademarks. But do all the marks be well? What is the category? What is the criteria for a well-known mark? That is nowhere mentioned. Now, what about a normal mark? Maybe I am a person who is having a well reputation in a particular country, and I would like to give the offer the product to my consumers throughout the globe. I may not be considered to be having a well-known status, so my protection gets affected. So, and suppose I'm a consumer who believes in a local mark and who is a consumer of a local mark. And one fine day, I wanted to purchase the product online, and with the advancement of technology, you can see all the products online, right? So what will happen is, like, I may end up purchasing product which is not the original one. So if the transporter reputation of mark is not being conferred, there are chances that people may get confused. People may end up buying products which are not something which they are seeking for. And another concept under the trademark law is Section 12 of the Act, that is honest and concurrent use. So the law is permitting two particular marks to coexist if they are able to prove that there is an honesty in their usage and they are using the product for a long period of time. Now, is this provision, Section 12, against the right of a consumer? Yes, it is. According to me, it is against the right of a consumer, because if two marks are allowed to exist together in the market, whether a consumer, I being an ordinary consumer, whether I will get confused, whether I end up purchasing a product which I don't desire to purchase, and whether maybe the standard or maybe the product is not as per my expectation, I may end up refusing to purchase refusing to purchase the product in the future. Whether my safety is getting affected, that's a big question which has to be taken into consideration. So according to me, the section 12 especially is against the basic.
Yeah, madam, please conclude.
Yes, sir. Just in 1 second, 1 minute, I will conclude.
Yeah.
Basically, according to me, this honest and concurrent usage, this thing is against the right of the consumer. Now, when you see a particular mark online, when you do a trademark search, the trademark registry portal, you can see that there are many marks which has been existing together. That is, there might be, for example, a Tiger mark will be in the same class with the same goods. It will be existing together. And most of the marks may have already got the registration done. Whether that is against the right of a consumer, whether the act which primary objective is to protect the right of consumers, whether it is actually violating the rights of a consumer, that is something which according to me has to be looked into. And so my suggestion or my conclusion on this paper is that regarding the transborder reputation of the trademark has to be re-looked into. Similarly, section 12, that is the honest and concurrent usage of a trademark, also has to be re-looked into, taking into consideration the change in circumstances and change in pattern of the registry in giving protection to almost all kind of trademarks. Thank you.
Thank you very much, Navanita ji. So now we'll move to the question and answer session. So first, any participants in this parallel session to have the questions can ask and to directly can ask to the presenters. So in case of after those questions, the chair, we two people will pose the questions to the presenters. After that, feedback and of the complete session is concerned. Any questions from the participant side? No questions? Okay, then let me ask, not question, it is like some interaction with the presenters, both the chairs we want to interact. The first presenter, Faisal and Arjita. Am I audible, Mr. Faisal?
Yes, sir, you are audible.
Okay. Okay. So nicely presented. Anyway, in feedback, we'll see. You people talked about Bolam test and all. But what I would like to know in respect with all the presenters. So how your this Bolam test or limitations given under the Bolam test, whatever, how you are applying to the Consumer Protection Act 2019, how the medical negligence cases in India to be dealt up with that, what is the present status?
Sir, so basically what we are talking about is that Bolam has been there and it has been routinely applied in India till date. But the problem is that as there are new facets of Consumer Protection Act with the 2019 Act also, which also came. So it's not just specifically about the 2019 Act, but about the new facets. So many new things are being introduced. So why not, like other common law countries or advanced countries, why don't we give up Bolam and make our own standard of, judging medical negligence? Because suppose in Australia, there is the Roger versus Whitakers, or even in UK only there is Bolitho. So many developments are happening. So when there are so many new facets in our Indian perspective as well, so why do we routinely apply Bolam when even it is not applicable properly? So we should just innovate ourselves so that even medical profession has some sort of innovation, improvisation, and other things can be like the limitations can be
do you think what steps to be taken in order to promote patient protection is concerned from the professional negligence or medical negligence by the professionals?
Sir, so first of all, we have to judge what is the standard accepted practice. Because as Sir Faisal sir also said that, it's we cannot judge it like there are, we can say that a fracture, like if a fracture happens, surgery is also an accepted practice, plastering is also an accepted practice. So now if we say that, okay, we can't decide on the basis of that for this particular case surgery is the accepted practice. We have to judge for that particular case. So there should be more better standards, and it cannot just be on the basis of Bolam, which says that any accepted practice is acceptable, because it also depends upon case to case basis as well. So we cannot just give it as in general that, okay, any accepted practice can be applicable. Also, suppose we have some sort of medical innovations. Always, suppose recently we saw some cancer drug has been innovated. So if we do not get into the accepted domain of that, suppose a new researcher who has invented something, who have developed something, and I know as a doctor that I can give that to a patient, even it is from the doctor's perspective as well, that I can give it to a patient and that patient can recover through that. But I can't, because if I give that patient might, it can like have some other implication as well, and that patient might die. There is obviously a chance, or some sort of implications might happen. And then I'll be judged in the court that I did not follow the accepted practice. However, that was an improvisation. So we are actually giving up improvisation in the name of Bolam. So we have to look into that perspective when we are developing our
Okay, thank you. So Sanjay sir, any questions?
No questions from my side, sir. I found only one issue, that is the analogy they give. I am not happy with that analogy.
Okay.
See, if a person who is suffering from some injury, some fracture, if he goes to a doctor who has qualification of MD, then he will apply the reasonable care. If he can judge whether it requires surgery or it can be cured by medicine, he can judge it.
Sir,
So,
yes, sir.
Yeah, first let him complete, Archita.
Yes, sir.
So even Faisal gave same analogy. So that analogy cannot be perfectly applied here.
Sir, can I know why not?
You need to justify it better. Yes.
Yes, sir. So another thing which Sir Faisal sir also said, that there is one problem, that suppose I am a doctor, suppose if I give a heart example, okay. So some doctors say that, okay, you are having heart blockage, you have to conduct bypass surgery. And some might say that you have to put a stent, right? So maybe I am a doctor who always is specialized in the stent putting surgeries, not the bypass surgery. So as a doctor, I know the stent surgery, and some other doctor is very specialized in the bypass surgery, suppose. So if I, being a doctor, if I see that, okay, the stent is not available right now, there is some problem, and I conduct the bypass surgery, just because it is also an accepted practice. Definitely it is an accepted practice, but I am not specialized in that. So is that permissible? Bolam accepts that. Any accepted practice can be done. But I am not a doctor who is specialized in that particular thing, right? So in the paper also, we analyze various cases, as sir also said, that we analyze 135 cases, whatever cases till date regarding NCDRC, we have analyzed everything. So among them, there is one case which talks about a child who has gone to a doctor, right? So the doctor gave some medicines and there was some problem with the dosage and the child died. But the doctor was not specialized in, he was not a pediatrician, but he was a doctor. He was an MBBS doctor. So is that permissible? Bolam actually accepts that because it is an accepted practice. The doctor is giving medicine, but we cannot justify that because that person is not specialized in this, and a little mistake of that person costed the child his life.
Okay.
Yes, sir.
So we'll move to the second presenter, Vikranta. So I have a very small, question to you. How will you make the extraterritorial applicability of the grinder? Because the Indian Consumer Protection Authorities, suppose you take a competition law. So when there is effect, on the Indian relevant market of the Indian consumers, right? So any anti-competitive agreements which takes place outside India, so the CCI which come into the picture. So at par, how the consumer protection authorities can make liable of this grinder at the same par with like CCI in the competition law respectively, or if there are any instances in India like similarly the activities which have taken which affected the consumers or the service, particularly in this online based applications is concerned. What do you say?
Yes, sir. Thank you so much for the question. So in the exam, I'll answer one of the sub questions that has this been done. There's a very famous case called Republic of Italy v. Union of India, where it was held that India as a home state can sort of exercise extraterritorial jurisdiction as long as it benefits the people of India. As long as you're able to say that there is a real effect, that a real nexus with the people of India. So if you see recently, there was a situation where Google was fined a heavy fine, even though, and if you look at the case, it was Google USA that was fined. The reason for that is may or may not have applied the same principles of the extraterritorial jurisdiction, but the same ideals come into place that Google, being an international body, being an international entity, still is liable to the activities that it does within the Indian jurisdiction, because it is Indians who are affected here. It is Indians who bear the direct consequence of these omissions, of these actions that is done by foreign entities. So Grindr in this place again becomes liable under the same context. If I can actually direct you to a case which is called Cybercell Inc. v. Cybercell, where it was very famously held that even if you have a website which is located outside India, if you are able to prove that the website has been directed towards the people of India, which in this case it is. India has the second largest number of users in India on Grindr. So Grindr is obviously directed towards countries like India. So obviously it has a territorial nexus. It has a consequence of the people. So all of these cases with different high courts and Supreme Courts allow us to have extraterritorial application of the Consumer Protection Act.
Thank you. Sanjay sir, do you have any remarks or observations?
Yes, sir. How you are going to charge for tort of negligence for the grinder if a person has not paid the consideration?
Tort as such does not require you to have consideration. Tort of negligence only rests on one and one clear, although there might be multiple aspects to it.
General tort, right? It doesn't come under the Consumer Protection Act, right?
Yes, sir. So, yes. But it does not mean just because a free version of Grindr does not come under Consumer Protection Act, I did not want to exclude them from the ambit of any protection possible. So they can go towards tort.
Then under the Consumer Protection Act, if a person has not paid the consideration, you cannot bring that person under the purview of Consumer Protection Act.
No, sir. Unfortunately, that has not been the
tort. So that is negligence.
So you're inaudible, sir.
Sorry. The only remedy is general tort. If a person has not paid the consideration, the only remedy is in general torts. He cannot seek any remedy under Consumer Protection Act, right?
Yes, sir. So because the paper was more or less directed towards new facets of consumer protection, there might be remedies under other statutes and other laws of India. But I wanted to focus on, how Consumer Protection Act. This is actually one of the recommendations I've made in the conclusion of my project, that it is very important. There are so many applications that more or less all of them are free. But the Consumer Protection Act, even the 2019 amendment, has left out these free applications outside its ambit. And we have blindly applied the Indian Medical Association VP Shanta case to say, yes, services free of charge should not come under Consumer Protection Act. But do you see the wide amount of applications that is automatically gets disqualified? So I feel this is a recommendation. This is a lacuna within the Consumer Protection Act.
More research needs to be conducted on indirect consideration, indirect payment of consideration.
Sir, the thing is, I did, which is why I included a part that if you pay fees for the internet that you use, would that be considered? If you pay any money to Google, because at the end of the day, you download the application from Play Store, does that amount to consideration? So in multiple judgments, it has been held that these taxes that you pay or indirect subscription that you pay to these platforms, they do not amount to payment that you make to your service provider. So Grindr, unfortunately, similarly, any free application for that matter, be it Tinder or be it
Till
Facebook.
Vikranta, what I also feel,
Yes, sir.
but even if you are distinguishing a free user and a paid user. So
Yes,
paid
sir.
user, which comes under the ambit of Consumer Protection Act,
Yes,
but
sir.
a free user, which will be converted later on a paid user.
Yes,
free
sir,
user
it
can be potential paid user.
Yeah,
Yes,
see,
sir.
so because of the user strength only, the company name, fame, everything which is
Yes,
comes
sir.
into existence and everything.
Yes, sir. True,
So
sir.
the law, even the consumer protection relating to the application-based services is concerned, even a normal user
Yes, sir.
is
Yes,
also
sir.
to come into the ambit. What I feel.
Yes, sir, even if you consider free users to be potential consumers, because the Consumer Protection Act of 2019 considers potential consumers also to a particular service. But unfortunately, only roughly 18% of the global population who is on Grindr uses paid Grindr. So I wanted to include free Grindr more or less to say that an explicit provision needs to be added, sir, about these applications and these services which are rendered free of charge. We just cannot blindly use a VP Shanta judgment to exclude services free of
Thank
charge.
you.
Thank you so much, sir.
I think last time I saw you in Bhopal.
Yes, sir. Yes, sir. We met together in Bhopal, sir. Yes, sir.
Yeah.
You were in my panel for the autonomous machines.
Correct.
Yes, sir.
So moving to the third presenter, Shreyas and Kutika. So just a very simple observation, and would like to know, there are any international conventions or international practices which adopted in the particularly visually impaired and recognized as consumers, and also they to be protected, like any international conventions or practice, any research which you people made?
There is an organization called OECD. The organization is the Organization for Economic Cooperation and Development. It is in respect to the European Union, for that matter. And in that, one of the principles, that is Principle 24, states that the regulatory aspects of marketing must also consider the differently abled segment of consumers. And other than that, there have been parliamentary deliberations in the European Union, for that matter, where there is a reference that is made to the vulnerable sections of the society and how they must be protected, from unfair trade practices. And apart from that, they have
the UNCRPD. We should not forget, sir. The the United Nations on Right to Persons with Disability.
Okay.
Yeah, that apart from that, in India as well, there is this RPWD Act, and in America, the American Disabilities Act as well, which also had a good amount of hold when it comes to the aspect of including text to speech and all of that in telecommunication services. And there was also this treaty that was given by the WIPO, sir, the WIPO Marrakesh Treaty. So that also prevented the audiobooks, like from coming into certain intellectual property copyright infringements, because it enabled the hard copies to be converted into audiobooks, and so without any copyright infringements, for that matter.
Yeah, my coach, Sanjay sir.
Yes, sir. Krutika, somewhere you said the discrimination is being made against the person with disabilities or blind persons, and you said there is lacuna in the Consumer Protection Act 2019. What is that lacuna? Where do you want to include that provision? Under unfair trade practices, or deficiency in service, or defective product fair, or misbranded goods fair? Where should it be included?
So I would say that since I have come across one of the instances where once the website did get to know that the visually impaired person is availing the good, they suddenly charged higher prices, and this was one of the situations that happened in America, for that matter. So I would say that for the fact that it is an unfair trade practice in that matter, because they are misusing the situation that a consumer is placed with due to the potential manufacturing, or basically the the very fact that the person is blind and visually impaired, that is being misused for the fact to increase their prices in excessive pricing. So I would say it is an unfair trade practice in that manner. And apart from that, so I would like to slightly say that on the face of it, the act itself is not discriminatory, because it does not exclude the visually impaired as potent consumers, because as consumers, even visually impaired are included in that. But I would just say that there is no complete effectualization of the objectives of the act in giving whether it is timely justice to the visually impaired because of inaccessibility to the fora. And yeah, so I would say that for that matter, any product that they do buy or any service that they avail is deficient, because uh, the very fact that it is not accessible to them, and the very fact that they're not able to choose or get the adequate information of the goods or the services that they're to be availing, I think that the fact itself makes it a prima facie defective and a deficient service, sir.
Thank you.
Okay, thank you. We'll move on to the fourth presenter, Navanita Warrior. So yeah, actually the essence of trademark must be non-deceptive and no confusing. So, but other side, every day in their lives, the consumers are facing in confusing and deceptiveness of a trademark is concerned. So, how do you the Indian legislation framework, either in Trademark Act, or in the Consumer Protection Act 2019. So to protect from this deceptiveness and deceptiveness and confusingness.
Okay, so basically, sir, yes, basically, sir, as you have rightly pointed out, the objective of trademark law is to avoid deception or confusion. And see, according to my understanding or according to my limited knowledge, the Trademark Act is not effective in protecting the right of consumers, because one of the objective of the trademark law is also to protect the consumer interest. Now, if you see the trademark portal, for example, you can see similar marks as well as identical marks of the same relating to the same goods and same product or same services like being registered or like applied for registration. But when we see the registry has given the registration for both the marks. So according to my understanding, our legislation is lacking behind in protecting the right, in looking into the protection of consumers. They are just looking into the right of a manufacturer in getting the protection, lacking behind when it comes to the consumer rights, according to my observation. So
okay, Sanjay sir.
Thank you for the question, sir.
Yeah. Sanjay sir.
Yes, sir. How you are going to link your topic with the Consumer Protection Act? It looked like it is more on Trademark Act. So.
Okay, sir. So what I have done in my paper is looking into the consumer rights from the point of view of trademark law. So I'm looking into, or I am trying to point out that what trademark law is doing is not protecting the interest of the consumers. It is violating the right of a consumer by looking into various provisions. So trademark law, one of the objective of the act is also to protect the right of the consumers apart from the interest of the manufacturers. So what I am trying to point out through various provisions, it is evident that that particular objective is defeated, or that particular law is defeated. So our rights being a consumer is affected badly. So I'm looking, basically my analysis is the trademark law from the point of view of right of the consumer, sir.
Okay, thank you.
Okay, so coming to the last address of the chai persons and final feedback, just I would like to tell upon how this consumer disputes can be get down. One of the new facet of this consumer disputes to come down is introduction of the mediation. So previously, the mediation was not the informal justice system, not particularly in the Consumer Protection Act 1986. But in the in the 2019 legislation under the chapter 5, they introduced this mediation to settle consumer disputes, particularly is concerned. In case of you see the total pending cases at the various consumer commissions level, you take it national commission or state commission or the district commission, around 4,26,000 from the recent data is concerned. This pendency is really impacting the rights of the consumers in India is concerned. So the best and better solution to decrease the case load is the mediation. Mediation is a voluntary process which need to agree by the both the parties, where the egos of the parties which involves and to be satisfied with the help of the mediator is concerned. So really this mediation is the game changer, but there are lacunas in the legislation under the Consumer Protection Act 2019. They not made any mandatory mediation. What the process is, they have to refer the consumer commissions at different levels, the members of the commission which need to refer the parties to, in case of both the parties are interested. But in case of, you see, in some Western jurisdictions, the mandatory mediation was existed even in Italy, the particularly solving of the consumer disputes is concerned. And also the ODR need to be explored. Like OCMC is the center, the government of the Department of Justice is supported. So like the online dispute resolution platforms are the institutions need to be recognized in order particularly to solve the consumer disputes is concerned, and need to promote this online mediation. The online mediation was recognized under the mediation bill. The mediation bill not became the legislation, but very soon hope so that will become a legislation is concerned. The concern is these mediation institutions, the dispute resolution institutions, which is going to conduct an online, and also even offline institutions in the consumer dispute resolution is concerned to be recognized. And the second important thing is the creation of mediation awareness. In this morning, Professor Kare and Professor Keshav Rao was talked about this awareness, the consumer rights awareness. Maybe at the school level or at the different levels, this consumer awareness and consumer education, including mediation awareness to solving of the consumer disputes, may be promoted, and voluntary mediation to be promoted. And also before even actually after referring the case to the commission is asking to go for a mediation. But even at the pre-litigation stage, in case of we start with the mediation, the impact is much more, in order to solve these disputes is concerned. And also techniques like MEDARB or RMED, these type of techniques like hybrid models may be promoted in to resolve consumer disputes through the mediation is concerned. And also, and even this morning they talked about Swiggy and all. So even the third party like intermediaries, the Swiggy and also to be made party to the consumer this in order to protect the consumer rights and consumer protection is concerned. And also how a technology can be used in solving consumer disputes is also a question we need to work out. And also there may be a consumer protection officer in case of, you see, a data protection bill. So there is a data protection officer to every organization. Like there may be a consumer protection officer for for every entity or an enterprise or an institution who is offering this, so producing products or services. That can be a good idea to furthermore protect the at the first instance only the consumer protection officer may take some steps in order to protect the consumer rights is concerned. Coming to the feedback to the presenters of the this parallel session. First presenter briefly very presented well, both Faisal and the questions were answered by Ajita. So which presented on the topic a critical analysis of the Bolam test as a basis of determining professional negligence with special reference to medical negligence. they analyzed about Bolam test and how the Indian courts, which interpreted in their 1995 Indian Medical Association versus VP Shanta case, and analysis, limitations, and two principles, and how it is applicable to the Consumer Protection Act is concerned. They very well, see, basically, for a professional negligence, what constituents for a negligence is a legal duty to exercise with due care on the part of the party complained of towards the party complaining the former's conduct within the scope of duty, and when the professional breach of the same duty, then it leads to the consequential damages is concerned. So in the landmark Bolam case, what has been held, in the ordinary case which does not involve any special skill, negligence in law means a failure to do some act which a reasonable man in the circumstances would do, or the doing of some act which a reasonable man in the circumstances would not do. And if that failure or the doing of that act results in injury, then there is a cause of action. Thus, the understanding of negligence hinges on the reasonable man. So, fairly good presentation, and maybe my observations include, they can work it out, how the test is applicable to the Indian, medical negligence cases, how to come down these cases at different levels of commissions. You take national commissions or state commissions or district commissions. So that is one angle. The second presentation given by Vikranta is Grinder responsible and liable for the criminal offences committed over its application against its users. Nicely presented this topic. Grinder, he mentioned about the Israel application, which Israel entrepreneur which developed, how the LGBT community which connected through location based, and in India particularly a lot of criminal offenses which is taking place on the basis of usage of this Grinder. So the criminal offenses leading to, he fairly pointed out the case of Indian Medical Association versus VP Shanta, and what is the modus operandi of the crimes over Grinder, and deficiency in services, and extraterritorial applicability of the usage of the Grinder, and the effects on the users in India. You see, basically, once an application, which have been utilized, the users, the particular application, is responsible to protect the interest of the particular users, either data or by the usage of fake identification of the data is concerned. The Grinder shall be responsible, and Indian jurisprudence need to work it out in that a way, because a lot of applications which are the Indian users are using, which is affecting the Indian users of these applications is concerned. The third present, we are running out of the time, but anyway, quickly I'm going to wind up. So the third presentation given by Shriyash and Kritika, inclusion of the visually impaired as potent consumers and its applications on a compelling necessity. Visually impaired, yes, of course, they need to be protected. Because they are the also consumers. They given examples with shampoo and other air conditioner, etc. How to because they are these vulnerable sections. So really, very difficult to identify different products and services is concerned. They are at the lowest level to be affecting by these multinationals or any easily get effects. The violation of the consumer rights is concerned. What they answered regarding some lacunas in the protection of the consumers in our act, and what my observation is in the acts itself, some recognition which to be given, and it is really a need of the hour. In case of in the European Union and all, there are certain directives which works relating to the this visually impaired protection is concerned. So there is an Affordable Care Act in US, and there are certain assistances which are given through technology also, which existed relating to the who's having consumers with disabilities is concerned. That options can be explored in India further to protect the visually impaired people is concerned. So the last presentation given by Navanita, protecting consumer rights under the trademark law. Yeah, see, trademark law allows a dual system of protection. One based on registration of trademarks and other based on actual use in the market. Right, a trademark can be protected either a registered trademark under the relevant statute, or can alternatively be protected, alternatively to be protected by passing of action. We know. See, basically, in case of we see the Supreme Court in the Cadila Pharmaceuticals case, so enlisted some factors to be considered while deciding the question of similarity, the nature of marks, degree of resemblance, the nature of goods or services, the mode of buying of the goods or availing the services, because these are interlinked based on the deceptionness and based on the resembleness. The consumer might get a fact, by want to buy one product or service, but due to resembleness, due to the similarity, which may buy another product or service, and which may affect the consumer right is concerned. So and also she talked about trans-border recognition to the well-known trademarks. Normal trademarks are getting affected. How this resembling trademarks affecting the consumer, she have answered very well. What my observation is, so how she can conduct the research, how this consumers to be protected under the Consumer Protection Act 2019 by the by the practices of the these corporates, while usage of this similarity of the trademarks is concerned. Any lacuna which we may identify, and which we may suggest to protect the consumers by usage of or by the trademark is concerned. This is from my side. All the four presenters did well, so thank you very much.
Okay, thank you everyone. As I have said earlier, we really witnessed a special session, and because our researchers, they have explored new challenges, they have exposed new challenges, and it was really a good session. And since we have left only 4 minutes for valedictory, I would like to request Ms. Anushka for vote of thanks. Over to Anushka.
Yes, sir. So good afternoon, everyone. I'm Anushka, a student at the National Law School. Today, on behalf of the NLSIU Chair on Consumer Law and Practice and the IJCLP, I would like to extend a sincere vote of thanks to everyone who took time out of their busy schedules to give us an extremely insightful presentation, as well as recommendations on various fields of consumer law. Now, the presentations, which spanned broad topics ranging from the Bolam test, which is ordinarily used in medical negligence claims, to the inclusivity of consumers on ordinary platforms, have certainly broadened our perspective and exposed us to various entrenched difficulties in matters of consumer protection. First, Mr. Faisal and Mr. Arjita gave us a comprehensive overview of the application of the Bolam test by courts, and they also persuasively argued that the court should apply this test only in cases where special skills are involved, as against a blanket application. Mr. Barse, secondly, he emphasized the way in which apps like Grindr function like double-edged swords, wherein provisions that ensure privacy for users often end up being abused to facilitate criminal activities. He also pointed out that such apps should incur additional responsibilities upon themselves to further consumer protection by virtue of these criminal activities being reasonably foreseeable. Thirdly, Mr. Shreyas and Ms. Kritika highlighted the compelling necessity of including visually impaired individuals into the ambit of the Consumer Protection Act. They also recommended a rigorous reconstruction of the consumer framework in India to accommodate visually impaired persons through tools like Braille, by using canes, etc. Ms. Navanita also provided us with a clear view of the importance of consumer protection in areas involving trademark law. She demonstrated the legal gray areas that exist in providing trademarks to consumers. I'd like to thank them all once again for investing their time and resources in researching on their areas of law. Lastly, I would like to thank the chairpersons for ensuring the smooth conduct of this conference, for their valuable input, and for making such a phenomenal event possible. Thank you, everyone.